I'm going to deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not going to have folks coming over to his mother's house because, young man, how old are you?
24.
Yeah, she does not have to give you a home. I'm sorry, Ann Arbor Township. Okay, so they occurred in two separate jurisdictions. Okay, that's why you have two separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we are also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 1227 and 1230 for cocaine. He did already send out the 1227 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that that be addressed at that time.
Buckle up, guys. Today we are going to watch a courtroom moment slowly tighten. The judge lays out firm boundaries, explaining housing isn't guaranteed and mental health court looms ahead. Tension rises when the defense asks for time, revealing 2 cocaine positive tests. Despite denials and a plea for patience, the court presses for clarity, making it clear this case is no longer routine but standing on the edge of serious consequences.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You're going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only. This is probably the least case that I'm worried about. I'm on GPS tether. I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything out on the line. So if we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. That's it, in the courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress report.
They're absorbing cocaine. And I'm not sure how that happens. young lady appears at community corrections, said, I smoked it around him. That must be how he's testing positive. You believe that?
That's
You believe, hold on, no. You believe that?
yes, Your Honor.
Really?
That's the truth.
Council Pro, you might want to just be quiet, because the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Council approach. Anything else you want to say?
No.
I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court date.
I'm not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
As the discussion continues, skepticism takes over the courtroom. The judge openly questions the truth, dismantling explanations about second-hand exposure and warning against dishonesty. Each answer seems to deepen the concern, not ease it. The moment turns sharp when the judge revokes bond and orders the defendant remanded, signaling that trust has broken down and the stakes have officially escalated.
Thank you, Your Honor.
He's asked that we address bond again today. I have made a number of contacts. I've reached out to his community corrections agent. She indicated to me that in order for him to get into CCOP while in custody, the court would need to send over an order to their attention so that they could at least start the process. However, he wouldn't be able to do the assessment until he's out of custody. So I guess our first request today would be that the court consider an order allowing him to enter the CCOP program so that he could be assessed. I also reached out to Matt Statman to see if he could come to the jail and do an assessment. I know that the court would like to see some type of plan in place and to address his sobriety. He didn't want to address the court again today. He indicated that he wanted to take responsibility and be open and honest to the court and explain to the court exactly.
So what changed? Why does he now want to be open and honest?
I think primarily, Your Honor, he indicates that he was extremely shameful of what had happened. I think he could better say it in his own words. His family is here. He knows that he's let them down significantly over the past few years. I think this started back in 2023, right?
Yes, ma'am.
Yeah. So he knows that he's let them down, and he just has not been very open with himself about the extent of his addiction. He and I had a great conversation. He has a lot of insight, and he told me himself that he is not great with words, but he's going to do his absolute best to try and express himself to his honor so that he could see and understand where he is in regards to.
His mom and dad here?
They are. His mom is that your dad?
Mom and sister.
That's both of them.
No. This is my mom.
His mother is here, Your Honor.
What do you want to tell me?
First of all, I want to apologize for being dishonest with you. Like I say, whatever we can do to move forward and help me with the problem that I have, I just want to do the right thing, Your Honor. I'm not even gonna lie to you. Like I said, I'm not the best with words. So
I'm understanding everything you're saying.
I know. I just ask for another chance. Honestly, I do.
Well, not funny, but why were you lying to me? Matt,
I was just in disbelief.
I mean, did I look like that stupid? I mean,
No.
Huh?
No, I was lying to myself, honestly.
Point. But you had lied to your mother about that, right?
Right.
Right?
Yes, sir.
Because see, most people don't think I remember anything, but Mama was sitting on that side. All of a sudden, you may not have seen this, but all of a sudden, her baby was about to be in trouble, and Mom came all the way from that side over here because Mom was going to jump up and say anything she could to try to defend her child. Mom, am I right? And then the biggest disappointment was on her face because she couldn't defend you. So more than what you did to me, more than what you did to yourself, you did that to your mom. And I'm going to tell you, the way I am, that sometimes is a harder thing for me to forgive when you do that to your mom. Because I when I saw her coming over, I said, oh, what's she going to do? But because she was going to battle for you. And that's who you really let down. You got me?
Yes, sir.
All right. So, Ms. Acker, what kind of plan?
So, Your Honor.
I mean, I understand the CC. I get that part of it. But what kind of plan is in place for him so that I don't let him out of here and then next thing I know, I'm having to put him back in because he can't?
And Your Honor, I think that I spoke with Mom today, and I know he was on tether initially. And I think Mom, again, not realizing the extent of the issue, understood that he could not go, but people came to the house. And that's where his next level of exposure happened. And I told him, I said, the tether can keep you from going places and have them monitor you, but it obviously didn't stop you from testing positive. And he explained to me that it was due to influences that he had allowed back into his circle and his bubble. So what Mom has assured me of is that now that she knows that his access is not just based on him going out, she, with it being her house, is also going to limit or prevent anyone from coming in to see him, especially while he's in this very vulnerable state and until we can get him secured into some type of treatment. That was the commitment that Mom made to me today. I will say something too, Your Honor. When I had spoken with him, this is part of what I was expecting him to say to the court. I asked him, I said, so why did you lie? And he said, because my mom was there and I didn't want to tell her the truth. I wasn't here at that last hearing, so it is quite funny that the court is able to see exactly what the root of that particular situation was.
I could see it on Mom's face. I just didn't know who it was going to come at. I didn't know if it was going to be at me or what it was going to be at, but I could also see the hurt on her face. And young man, you got to do better.
Promise to. I promise I won't drop dirty again.
All right, here's what I'm gonna do. At this juncture, secondarily, I'm gonna, well, is there anything from the people?
We'll leave it in your discretion, Your Honor.
All right, here's what I'm gonna do at this point. Secondarily, I'm gonna deny the request right at this moment. I want in writing what is basically the plan.
Okay.
That it would be reinstated. He's not gonna have folks coming over to his mother's house, because young man, how old are you?
24.
Yeah, she does not have to give you a home.
Mhm.
You got that?
Yes, sir.
So I want that laid out, that this is what the defendant is willing to do. I understand what mom's going to do in terms of protecting her house, but I want what his commitment is in writing. So if he messes it up, it's his word. It's not something mama didn't do. All right. And then I will consider, I'll look at that and based upon what we talked about, try to get him released. I want also in there the CCOP portion of that in the order, and then I'll look at and do that. Okay.
Okay, so we'll look at the order after we get you the plan.
You get us a plan, and then you just prepare an order for
Absolutely.
these, but I want everything laid out, spelled out as to what he's going to do.
Understood, Your Honor. I'll work on that today.
You're not an amoeba. I'll have him look it up when he gets out as to why I'm saying it. He knows why I'm saying that.
Thank you.
I was just in the room, and that's how I now go. Young man, you break that woman's heart. I don't.
From here, the tone shifts toward accountability and emotion. Defense counsel proposes treatment options while explaining the defendant's shame and fear of disappointing family. The defendant apologizes directly, admitting dishonesty. The judge focuses on the mother's visible pain, stressing that her heartbreak matters most. Despite empathy, the court demands a written plan before considering release, placing responsibility squarely on the defendant's shoulders.
Mr. Hampton has entered into an agreement with the people, and I'd like to enter that into the record.
The people of the
Thank you.
we did not write up the agreement. He has been admitted to the 15th District Court Mental Health Court.
Got it.
Today, at his preliminary exam in 24 at 55262. He'll be entering a plea on Tuesday to attempt RNO, and that case will go to the 15th District Court Mental Health.
Got it.
Your Honor, is it possible to enter into both today, to address both cases today on the record?
That file is not in the courtroom.
Oh, okay, got it.
But I do believe that the building that you faster.
Oh, sorry.
But I don't believe it's.
What? Okay.
Talking about violence.
All right, we'll just address this case today.
He's going to enter a plea in another case that's set for prelim.
Yes, yeah. So case 24F55262, just because of the timing with the mental health treatment court evaluation, that one was set for preliminary examination before the evaluation was complete. And that is currently set for exam.
So over there is Ann, right?
Yes.
You know Ann?
Yes.
Okay. So if you had this, that may work out where we could like get rid of two cases and he could plead. I may or may not do it, but usually just go over and ask Ann. Because you asked me on the record, I'll probably say no, because I don't do the filing, so I don't know where it is.
Understood. Yes. So I will.
So would you like to do that today?
I would like to.
So here's what I'll do. I'll pass it. Go talk to Ann.
Thank you very much, Your Honor.
You're welcome.
Your Honor, sorry. Ashley Bashir on behalf of Mr. Hampton. And in addition to addressing the case directly, we would like to address bond and request that a condition, specifically the home confinement tether, be reconsidered?
Okay, I'll get to that maybe at some point.
Good, thank you. Yeah,
Right now, I'm trying to get these pleas done.
thank you.
So my understanding is he's going to plead to count in case ending in 1596. He's going to plead to count 2.
Yes,
Correct? With count 1 being dismissed. That's going to be a guilty plea. Correct, counsel?
Yes.
All right. Then on the other matter, I have a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, count 1, the resisting and obstructing, would be dismissed. And there is an agreement that the defendant is to go to mental health court. That's the court's full understanding of the agreement.
That's right, Your Honor.
May I have the defendant's sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
State your name.
Brandon Hampton.
And man, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor offenses. Is that correct?
Yes.
All right. The first one, in the case ending in 1596, is the charge of aggravated assault. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also understand in that case that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yeah.
Okay. And understanding that on that case, do you still wish to plead guilty?
Yes.
All right. On the other case, it says court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that?
Yes.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Balvo in the 15th District Court. You understand that?
Why are the judges different, Your Honor?
Why are the judges different? Because these allegedly occurred in two separate places. The case that we're just talking about with Judge Balvo, the offense took place in the city of Ann Arbor. And the other case happened in maybe the city of Ypsilanti or yes, in Ypsi City, it looks like. I'm sorry, Ann Arbor Township. Okay, so they occurred in 2 separate jurisdictions. Okay, that's why you have 2 separate judges. But what's going to happen, I think this is probably really the crux of your question. You're going to go to mental health court on these, right?
Yeah.
So Judge Valvo is actually in charge of mental health court. So when that case goes over to her, that will be where it is. You'll have to go before Judge Barr. Judge Barr will do the initial part of the sentencing and then place you on probation to be supervised by the mental health court. Follow that? So it's just a little bit of a process. Both cases, it's anticipated, are going to end up in the same spot.
Okay.
Okay. You got that? Any other questions on that?
I guess it's not like possible for the other case just to go to Valvo as well.
It will get there. It just can't go directly that way.
Okay.
Okay.
For sure.
Anything else? Trust me, we do this all the time. It'll get there. So it'll catch right up to it. Okay. All right. Any other questions you have?
Just the one about bond, but
yeah, we'll get to that in a moment. All right. So understanding all of that, you still wish to plead guilty to these charges?
yeah.
Okay. So to the charge of aggravated assault, how do you plead?
Guilty.
To the charge of attempted resisting and obstructing, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
Yeah.
All right. You signed an advice of rights form, correct?
Yeah.
Do you have any questions regarding any of those rights?
No.
Attention turns to procedural ground as multiple cases and jurisdictions are sorted out. The court explains how mental health court will ultimately oversee both matters, even though different judges must handle initial steps. Guilty pleas are discussed, rights are reviewed, and the path forward is mapped carefully. What sounds administrative carries weight, as each explanation locks the defendant deeper into a structured legal process.
You see a copy on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes.
All right. Were you on probation at the time of these offenses?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
All right. Anybody threaten you or coerce you in any way?
Kind of.
Okay, what do you mean, kinda?
I don't want to go to jail again, Your Honor.
Okay, but did somebody threaten you to plead?
Yeah, with jail time, Your Honor.
Okay, but who did that?
Well, technically, you, Your Honor.
No.
Well, technically, you, Your Honor.
No.
Mr. Hampton, so
Tell you what. Why don't we pass the matter? Maybe you can talk to him and we'll give this another shot today if we're comfortable with it. Otherwise, the court may not be comfortable with it, and we might just blow all of this up and it'll just have to happen another way.
thank you.
But I'll give you a chance to talk.
We appreciate that.
All right. We're back on the record in the case of the people versus Hampton. We're in the middle of taking a plea. And so I stated the terms on the record. And Mr. Hampton, I'm going to ask you a couple questions again.
Okay.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
Has anybody threatened you or coerced you in any way to get you to plead?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and because you believe that you're guilty of these offenses?
Yes.
All right. We'll start with case 1596. Paperwork. So, okay, Mr. Hampton, on the date of August 29, 2024, at Washtenaw Community College in Ann Arbor Township, Washtenaw County, State of Michigan, do you recall what happened on that date regarding a Vladimir, is it Parahora?
I don't know, Your Honor.
All right. Did you get into a fight with somebody?
Oh, I know what happened. I don't know what his name is. It sounded like.
Okay. Why don't you tell me what happened then?
Oh, I was trying to take a shower, Your Honor.
Okay. And then what occurred?
When I was in the locker room, he had pushed me up against the wall, hit me in my head, and threw me on the ground. And then broke in my property.
Okay, but before that, did you do anything before that?
No.
Okay.
It wasn't until there were 4 people on top of me and I was fearing for my life that I bit him, Your Honor.
Okay. So here's what I'll do. Counsel, because I can see the way that this plea's going, it's not going to work. So if you guys want to change, I'm not suggesting if you guys want to change things to a no contest. If you want to do whatever, what I will do is I'm back up at 1. I'll call it back up at 1. I think everybody's still going to be here. So, and give you a chance to talk with him, decide whether or not you want to do no contest pleas, explain what a no contest, go through all of that with him, and then see if we can get this done.
Thank you very, very much, Your Honor. Appreciate it. Thank you.
This is a prime example for me of no good deed goes unpunished. All right, so we'll call it back up at that point. Quarter past these matters again. All right.
We actually, based on the most recent conversation with my client, I will actually seek to adjourn this case for to further advise my client on the offer.
All right.
For the shortest adjournment possible.
February 13th. Both matters.
Thank you very much, Your Honor.
Canceling witness.
Both matters?
Well, that's true. What are we doing with, well, when is the exam set?
Tuesday, the 28th.
Yes, so would it, apologies. We can see, I'd be happy to stip to adjourn that, the exam or for the other case.
Well, you're gonna need a step on the exam.
Yes.
But I only took it because there was gonna be a plea. When do you want the other one adjourned to?
When is the soonest?
I'll set this, I'll adjourn the
After the
1596. I'll adjourn 1596 to February 6th. The other one is stay on track for a preliminary examination. I understand that people are not going to have their witnesses available, or you need a stipulation to adjourn that out.
Thank you.
Okay.
Thank you, Your Honor.
And
The final stretch exposes how fragile plea agreements can be. While describing the incident, the defendant frames events defensively, prompting the judge to halt the plea and suggest alternatives. After consultation, counsel requests an adjournment to reassess strategy. The court grants new dates, leaving resolution unresolved but imminent. Like the video, subscribe to the channel, and we'll see you in the next video.